and we are going to finish the reading. And so I'm on page 62 of the 174 report. Hello, hello. Ouch. And we're in the part where they're talking about basically how they prove that each of these, how they have evidence that each of these falls under the category of the law. So I'm just going to start. I think people are just going to come in once they see that I'm talking about it. So it bears emphasis that dang it, I did it right off the bat. It bears emphasis that Mr. Orange's knowing deceit was pervasive throughout the charged conspiracies. This was not a case in which Mr. Orange merely misstated a fact or two in a handful of isolated instances. On a repeated basis, he and co-conspirators used specific and knowingly false claims of election fraud in his calls and meetings with state officials in an effort to induce them to overturn the results of the election in their states. To his own vice president to induce Mr. Pence to violate his duty during the congressional certification proceeding, and on January 6th as a call to action to the angry crowd that had gathered at the Ellipse. Oh, thank you, team with Teresa. Ellipse, and sent to the Capitol to disrupt the certification proceeding. Mr. Orange and co-conspirators used other forms of deceit as well, including when they falsely represented that the fraudulent electoral votes would be used only if Mr. Trump prevailed in pending contests in their states. And so they were tricking people into committing crimes. Like, you can't trick people into committing crimes. You can't say, oh, that candy bar in that store, I actually bought it already. Just go grab it and bring it out to me, and trick someone to shoplifting, Regardless of any claim that Mr. Orange subjectively believed the outcome of the election was unfair or rigged, the office concluded that these knowingly deceitful statements and acts would overcome any good faith defense. The office also expected that Mr. Orange might claim that his consultation with attorneys, several of whom were co-conspirators, should negate a finding that he acted with a criminal state of mind. So they thought that he would argue, well, my lawyers told me to do it. In pretrial litigation, the court granted the government's motion that Mr. Orange should be required to declare whether he intended to employ such a defense. So the court said, you need to tell us if that's what you're planning on saying. And if he did, that he had to produce the discovery required by the attendant waiver of Mr. Trump's attorney-client privilege. So you got to prove it. You want to say that your attorney told you to do it? You have to prove it, or else you can't say that. So Orange is such a bullshitter, right? He's on his phone every day talking about this and acting, and he's been told all this. He had to see this weeks ago. He's seen this report, and he was being interviewed, being investigated. He was being contacted. He was going to court and being told, hey, you're not getting away with these claims. And the way he manipulates and lies in public, I mean, I know a lot of people do that. I know a lot of politicians do that, but the way he goes over the top to manipulate his followers, and those are true followers, right? You come on my page and you follow me, you're just clicking to agree to see my posts in your FYP. But these are people following him, It's sick. It's really sick. I think everybody in here would agree. Okay. A defendant's claim that he relied in good faith on his attorney's advice is not an affirmation defense. I got a comment filter. I don't know why. Is not an affirmative defense that defeats liability even if the jury accepts the government's allegations as true, but functions instead as evidence that, if believed, can raise a reasonable doubt in the minds of the jurors about whether the government has proved the required element of the offense that the defendant had an unlawful intent. So, he's admitting that it's on him to prove that he had unlawful intent. The office concluded that if Mr. Orange chose to raise such a defense, it would fail because an advice of counsel defense is not available where counsel acts as an accomplice to the crime. Oh, so because his attorneys were co-conspirators, you also can't say, well, they gave me advice. Well, they were your co-conspirator. So you don't get to use that as excuse. And for anybody who's coming in who wants to follow along, I'm on page 64 and I'm just scrolling through. So if you want to find this, you just go to the Department of Justice. Just search justice.gov, Report of Special Counsel Smith, Volume 1, and it'll come up. I'm on page 64. The evidence showed that the central attorneys on whom Mr. Orange may have relied for such a defense, such as co-conspirator 1 or co-conspirator 2, were partners in a venture, with the result that any advice of counsel defense necessarily would fail. Co-conspirator 1 assisted with Mr. Orange in using knowingly false claims of election fraud in furtherance of the charged conspiracies. At press conferences, at hearings, I don't know who any of them are yet. Let me ask ChatGPT if they can figure it out. Hold on. So co-conspirator 1, which I'm guessing is Giuliani, because it says, this is my alleged thought, made a wide range of specific, though ever-changing, false claims of election fraud. Co-conspirator 1 continued to do so after his lies were publicly or directly debunked. Co-conspirator 1's involvement spanned from his insistence that Mr. Orange declare victory on election night, to the voicemails that co-conspirator left for senators on the night of January 6th. They have voicemails! What idiots! Using false claims of election fraud to ask that the legislators further delay the certification. Co-conspirator 2, which must be Meadows, or it might not be, I don't know, was instrumental in Mr. Orange's efforts to organize his electors to cast fraudulent votes and send them to the vice president, and then to pressure the vice president to use the fraudulent electoral certificates to overturn the election results. Maybe it's just louder for me. I can't even hear myself. Oh, you guys have heard the voicemail? I just can't believe that they would be that they're that arrogant, that they think they could just leave voicemails about this stuff. Throughout his involvement in Mr. Orange's conspiracies, co-conspirator 2 conceded privately to other attorneys, both private attorneys and those responsible for advising Mr. Orange and the vice president, that his plans violated federal law and would not withstand scrutiny in court. He said, what we're doing is illegal and it won't stand up in court. Oh, okay. And then there's 2 pages of citations with evidence, emails, voicemails, video at press conferences, text messages, video at the Pennsylvania hotel hearing, Michigan House committee meetings. There's just lists of where the evidence came from. He said that he knew that what they were doing wouldn't stand up in court. He conceded privately that their plans violated federal law and would not withstand scrutiny in court. Furthermore, Mr. Orange could not have succeeded in showing that he relied in good faith on legal advice from these attorneys. The evidence showed that Mr. Orange was not looking to co-conspirator 1 or co-conspirator 2 for his legal advice. Instead, he was the head of a conspiracy who sought legal cover from his co-conspirators. As co-conspirator 1 acted repeatedly in furtherance of the conspiracies, multiple advisors to Mr. Orange warned him that co-conspirator 1, which I think we're assuming is Giuliani, would not successfully challenge the election results and was not acting in Mr. Orange's best interest. Mr. Orange ignored them all because he was not relying on co-conspirator 1 as an attorney. These idiots. Similarly, I know, right? It's crazy. Similarly, co-conspirator 2's willingness to advocate for actions that he knew and even privately conceded were unlawful demonstrates that both he and Mr. Orange understood their role, that it was not that of an attorney offering legal advice on which Mr. Orange was acting. Okay, so then it says, for instance, in a lawsuit in Georgia, co-conspirator 2 filed a false certification by Mr. Orange after having written to other attorneys in an email that both he and Mr. Orange knew some of the allegations incorporated in the filing were inaccurate. So they just admitted all of this, and they have evidence that they admitted it. There is no getting out of this. Okay, let me continue. For instance, the lawsuit in Georgia, co-conspirator 2 filed a false certification by Mr. Orange after having written to other attorneys that they knew that these were inaccurate. And co-conspirator 2's decision to advocate for the vice president's counsel and chief of staff on January 5th that the vice president should unlawfully reject legitimate electoral certificates, an act that co-conspirator 2 had previously recognized was not supported by the Constitution or federal law, was a sharp reversal from his position just one day earlier, and happened only because Mr. Orange had made clear that it was his preferred strategy. The office was otherwise confident that it would be able to demonstrate that with respect to all attorneys, Mr. Orange could not meet the elements of the defense, such as the requirement that he make full disclosure to any attorneys of all relevant facts, and rely faithfully on their advice. As the district court recognized, the First Amendment embodies our profound national commitment to the free exchange of ideas, and it bars the government from okay, we know what the First Amendment is. At the same time, it is well established that the First Amendment does not protect speech that is used to an instrument of a crime. Prosecutions for conspiring, directing, and aiding and abetting do not run afoul of the Constitution when those offenses are carried out through speech. Consistent with that precedent, the original and superseding indictments recognized that Mr. Orange had a right, like every American, to speak publicly about the election, even to claim falsely that there had been outcome determinative fraud during the election and that he had won. He had the right, so they're saying he had the right to say that stuff if he wanted. They charged Mr. Orange, however, with using knowingly false statements to defeat a government function, injure the right to vote, and obstruct an official proceeding. That is, he made dozens of specific claims that there had been substantial fraud in certain states, such as a large number of dead, non-resident, non-citizen, or otherwise ineligible voters, or that voting machines had changed votes for the defendants. Those were factual claims that were verifiably false, and Mr. Orange knew that they were false. Mr. Orange then used those lies as the instruments of our 4 criminal offenses. Because he used those knowingly false statements regarding specific facts to commit the crimes charged, they were not protected by the First Amendment. Okay, and then it gives a bunch of case law explaining all of this. The First Amendment permits criminal laws that prescribe knowing or reckless falsehoods in connection with some other legally cognizable harm. Okay, in pretrial motions, Mr. Orange moved to dismiss the original indictment based on the First Amendment. So he actually filed, I didn't know a lot of these details, but he filed for a motion to dismiss, saying that he had the right to say these things. The district court denied the motion, finding that the indictment properly alleges defendant's statements were made in furtherance of a criminal scheme. And he lost to that. As the court explained, Mr. Orange was not being prosecuted for his view on a political dispute. He was being prosecuted for acts constituting criminal conspiracy and obstruction of the electoral process. And the fact that his alleged criminal conduct involved speech does not render the indictment unconstitutional. Because he was not being prosecuted simply for making false statements, but rather for knowingly making false statements in furtherance of the criminal conspiracy and obstructing the electoral process. There was no danger of a slippery slope in which inadvertent false statements alone were alleged to be the basis for this criminal prosecution. Other charges. The office considered, but okay, here we go. This is why they didn't do the Insurrection Act. The office considered but ultimately opted against bringing other charges. One potential charge was 18 U.S.C. 2383, sometimes referred to as the Insurrection Act, which provides that whoever incites, sets foot on, assists, or engages in any rebellion or insurrection against the authority of the United States or the laws thereof, or gives aid or comfort thereto, shall be fined under this title or imprisoned not more than 10 years or both, and shall be incapable of holding office under the United States, any office under the United States. That's 18 U.S.C. 2383, Section 2383, originated during the Civil War as part of the Second Confiscation Act of 1862. Cases interpreting this section are scarce and arose in contexts that provided little guidance regarding, thank you, Susan, regarding its potential application in this case. And then it cites a whole page of references. To establish a violation of Section 2383, the office would first have to prove that the violence at the Capitol on January 6 constituted an insurrection against the authority of the United States or laws thereof, and then prove that Mr. Orange incited or assisted the insurrection or gave aid or comfort thereto. Courts have found or described the attack on the Capitol as an insurrection. In Anderson Griswold 543, this is another case law, the Colorado Supreme Court found that Mr. Orange engaged in an insurrection as that term is used in Section 3 of the 14th Amendment. Federal courts in the District of Columbia have also used the term insurrection to describe the attack on the Capitol, but did so in cases where there was no criminal charge under Section 2383. And then it has references, citations. These cases, however, did not require the courts to resolve the issue of how to define insurrection for purposes of Section 2383, or apply that definition to the conduct of a criminal defendant in the context of January 6th. Okay, so that's basically saying that there is reference to what the law is, but they didn't clarify how to define insurrection for this law, okay? That's kind of what Mueller did. Like, we don't have the definition of collusion, right? So the office recognized why courts described the attack on the Capitol as an insurrection, but it was also aware of the litigation risk that would be presented by employing this long dormant statute. As this sounds like okay. As to the first element under this law, proving an insurrection against the authority of the United States or the laws thereof, the cases the office reviewed provided no guidance on what proof would be required to establish an insurrection or to distinguish an insurrection from a riot. Okay. Generally speaking, an insurrection is a rising against civil or political authority, the open and active opposition of a number of persons to the execution of law in the city or state. Then it gives references. Some sources distinguish an insurrection from a riot offense connected with mob violence by the fact that in insurrection there is an organized and armed uprising against authority or operations of government, while crimes growing out of a mob violence, however serious they may be and however numerous the participants, are simply unlawful acts in disturbance of the peace, which do not threaten the stability of the government or the existence of political society. Okay, so that definition is describing insurrection being that they're actually trying to take over the government, like if they went in and took everybody in Congress hostage and said, we're the government now, versus a mob acting crazy, I guess, okay? In case law, interpreting insurrection in another context, one court has observed that an insurrection typically involves overthrowing a sitting government rather than maintaining power, which could pose another challenge to proving beyond a reasonable doubt that Mr. Orange's conduct on January 6 qualified as an insurrection, given that he was the sitting president at the time. So you can't overthrow yourself. Okay. I'm on page 73. The office did not find any case in which a criminal defendant was charged with insurrection for acting within the government to maintain power, as opposed to overthrowing it or thwarting it from the outside. Applying Section 2383 in this way would have been a first, which further weighed against charging it, given the other available charges, even if there were reasonable arguments that it might apply. I have feelings about that. I think... No, it doesn't say Mr. Orange. I'm just trying to reduce the amount of bots that come in. As to the second element under section... So what they're saying in that first element is that there's no case history in the past where someone who was already in the government was accused criminally of insurrection, because they're not overthrowing it. They're trying to retain power. He's trying to retain power. That doesn't mean that the other people, all the little rotten oranges, can't be charged with it if that's what they believed they were doing. When they're saying, we're going to take over, like that's different. But for him specifically, They're saying, you know, there's no evidence that we could. I agree, user 2866. But that's what they're saying. So then he says, as to the second element under section 2383, there does not appear to have ever been a prosecution under the statute for inciting, assisting, or giving aid or comfort to rebellion or insurrection. Wait. No one's ever prosecuted someone for doing this. The few relevant cases that exist appear to be based on a defendant directly engaging in rebellion or insurrection. But the office's proof didn't include evidence that Mr. Orange directly engaged in insurrection himself. Thus, however strong the proof that he incited or gave aid and comfort to those who attacked the Capitol, application of those theories of liability would have had to be first. The office determined that there were reasonable arguments to be made that Mr. Orange's ellipse, you guys? Particularly when the speech is viewed in the context of Mr. Orange's lengthy and deceitful voter fraud narrative that came before it. For example, the evidence established that the violence was foreseeable to Mr. Orange, that he caused it, that it was beneficial to his plan to interfere with the certification, and that when it occurred, he made a conscious choice not to stop it and instead to leverage it for more delay. But the office did not develop direct evidence, such as an explicit admission or communication with co-conspirators of Mr. Orange's subjective intent to cause the full scope of the violence that occurred. I agree. Therefore, in light of the other powerful charges available, and because the office recognized that the Brandenburg Standard is a rigorous one, it concluded that pursuing an incitement to insurrection charge was unnecessary. So that's Jack Smith's words. By comparison, the statutes that the office did charge had been interpreted and analyzed in various contexts over many years. The office had a solid basis for using these sections and to address the conduct presented in this case, and it concluded that introducing relatively untested legal theories would create unwarranted litigation risk. They didn't want to risk it. They wanted to get him on these other ones that they were going to charge him with. Importantly, the charges the office brought fully addressed Mr. Orange's criminal conduct, and pursuing a charge under Section 2383 would not have added or otherwise strengthened the office's evidentiary presentation at trial. For these reasons, the office elected not to pursue charges for insurrection. Yeah. Republicans wouldn't hold back. They would just so now we have co-conspirator liability. The next section F is about the co-conspirators. I'm on page 75. As described in the factual recitation above, Mr. Orange was charged with participating in crimes with at least 6 co-conspirators. And the office's investigation uncovered evidence that some individuals shared criminal culpability with Mr. Orange. Following the original indictment on August 1st, the office continued to investigate whether any other participant in the conspiracy should be charged with crimes. In addition, the office referred to the United States Attorney's Office for further investigation evidence that an investigative subject may have committed unrelated crimes. Before the department concluded that this case must be dismissed, so frustrating even to read about. No, they can't. Yeah, right. Case Salmon. Well, it's not that they can't use Amendment 14. They can't use it criminally. It's not a criminal charge. Before the department concluded this case must be dismissed, the office had made a preliminary determination that the admissible evidence could justify seeking charges against certain co-conspirators. Because the office reached no final conclusions and did not seek indictments against anyone other than Mr. Orange, the head of the criminal conspiracies and their intended beneficiary, this report does not elaborate further on the investigation and preliminary assessment of uncharged individuals. This report should not be read to allege that any particular person other than Mr. Orange committed a crime, or should it be read to exonerate any particular person. So then it has part 3. This is the third part. It says the principles of federal prosecution. Thanks to everybody who's in here. Thanks for sharing. You guys, it's great to know that people are interested in actually hearing the document and not just watching, videos and not engaging with trolls and stuff. It's nice to have people in here, and thanks for following me. I'll try to follow as many people back as I can. I've only got like 100 follows left because I'm already up to almost 10,000, but thank you. I'm glad that you guys are interested. The principles of federal prosecution. So this is going to explain, they're explaining their process here to us. As set forth above, the office concluded that Mr. Orange's conduct violated several federal criminal statutes and that the admissible evidence would be sufficient to obtain and sustain a conviction. Therefore, under the long-standing principles of federal prosecution, the office considered 1, whether the prosecution would serve as substantial federal interest; 2, if Mr. Orange was subject to effective prosecution in another jurisdiction; or 3, if there existed an adequate non-criminal alternative to prosecution. So before they ended their prosecution, they tried to find anything else they could do that wasn't a criminal prosecution by the DOJ. The DOJ Justice Manual, as described below, multiple substantial federal interests were served by Mr. Orange's prosecution. He was not subject to effective prosecution in another jurisdiction, and there was no adequate non-criminal alternative to prosecution. Okay. The Supreme Court's decision on presidential immunity, handed down after the initial decision to prosecute and analyze below. See, right there, though, if the Supreme Court decided after he was already indicted and this was already happening, wait. Yeah, the court's decision was handed down after the initial decision to prosecute was made. It shouldn't be valid. It should be grandfathered in. You know what I mean? Although that decision prevented use of certain evidence uncovered regarding Mr. Orange's misuse of presidential power, he also engaged in non-immune criminal conduct that is set forth in the superseding indictment. Accordingly, this section discusses only evidence that was not immunized. Basically, we're only going to talk about things that he can be charged with because he was not immune. Okay, prosecuting Mr. Orange served multiple substantial federal interests. That's section A on page 77. Mr. Orange's prosecution served multiple federal interests, including the federal interest in the... So now they're talking about why it would have been good to prosecute him. The integrity of the United States process for collecting, counting, and certifying presidential elections, and in a peaceful and orderly transition of presidential power. The federal interest in ensuring that every citizen's vote is counted, the federal interest in protecting public officials and government workers from violence, and the federal interest in the fair and even-handed enforcement of the law. All of these federal interests, which are rooted in the law, the Constitution, and our basic democratic values, are substantial and command protection from Mr. Orange's criminal design to subvert them. 1. The substantial federal interest in protecting the integrity of the electoral process and the peaceful transfer of power was served by Mr. Orange's prosecution. As set forth above, the investigation revealed that Mr. Orange and others conspired to use false claims of election fraud in an attempt to disrupt the United States electoral process and obstruct the congressional certification of the 2020 presidential election results. Prosecution for that conduct thus vindicated abiding federal interests in prosecuting the electoral process, in protecting the electoral process and the previously unbroken tradition before Mr. Orange's charged conduct of a peaceful transition of presidential power from one administration to the next. These federal interests are fundamental to our system of government, favoring no particular administration or political party. Indeed, electoral processes like selecting the president are necessarily structured to maintain the integrity of the democratic system. Preserving the integrity of the electoral process and preventing corruption are interests of the highest importance. And then there's citations. The office was cognizant of Mr. Orange's free speech rights during the investigation and would not have brought a prosecution if the evidence indicated that he had engaged in mere political exaggeration or rough and tumble politics. As set forth in the original and superseding indictments, Mr. Orange had a right, like every American, to speak publicly about the election and even to claim falsely that there had been outcome determinative fraud in the election that he had won or that he had won. He also had lawful recourse to challenge the election results, including through lawsuits, recounts, and audits. In fact, Mr. Orange and his allies vigorously pursued these methods of contesting the election results, but they were unsuccessful. After Election Day,